welcome to our second webinar in the Caregiving Essentials Webinar Series. My name is Christine Kennedy, and on behalf of the Office of Alumni Engagement and the McMaster Continuing Education, I'd like to thank you for joining us to hear from lawyer Natalie Sanna about navigating legal essentials for caregivers, myths, facts, and next steps. Before I introduce our speakers, I'd like to take this moment to recognize and acknowledge the land on which this webinar is taking place. I'm here on campus at McMaster. It is located on the traditional territories of the Mississauga and Haudenosaunee Nations and within the lands protected by the Dish with One Spoon Wampum Agreement. It's my pleasure now to introduce our facilitator today, Donna Thomson, and our guest, Natalie Sanna. Donna is a caregiver, author, and educator. She is the author of 2 best-selling books on caregiving, including The Unexpected Journey of Caring. Donna also facilitates our free online course for caregivers, Caregiving Essentials, and she is a co-designer of the Creating Caregiver-Friendly Workplace course and co-designer and co-director of the Family Engagement in Research program here at McMaster. And joining her, our guest today is Natalie Sanna. Natalie is an Ottawa-based lawyer at Lafreniere Sanna Estate Law. She is dedicated to helping clients and their loved ones for and deal with disabilities, incapacity, illness, and death. From the beginning of her law career, she has been drawn to the area of wills, estates, trusts, and guardianship, as it allows her to serve her clients and their families on a personal level and develop lasting relationships. Thank you both for joining us from Ottawa. Hopefully the weather is as lovely up there as it is here in Hamilton. And I'll hand it over to you both. Thank you.
Thanks, Christine. Thank you all for coming today, and especially Natalie. Thank you so much for joining us today. I am so thrilled. You know, I remember the first time I met you was at a session. You were doing a public information session about legal matters for parents of children with disabilities here in Ottawa. And then you and I have kept in touch, and you've helped out our family. And I know how passionate you are about public education in the field of caregiving and legal matters that impact us for better or for worse in this role. So, Natalie, I just wanted to ask you, first of all, how did you become interested in this field of law? How did that happen?
So funnily enough, my law partner and myself, Chantel, laugh about it that neither one of us actually took wills and estates in law school because we didn't think it was an area that we'd ever want to practice in. I thought I would be a litigator. I love public speaking. But then, you know, realizing what litigation actually is, it's much too adversarial for me and very little of the public speaking, which I love so much. So we both kind of had non-traditional career paths, but fate brought us together in 2015 to, you know, create this or continue this practice that we're doing. And we couldn't be happier. We couldn't imagine doing anything else.
Oh, and it's just the two of you in your practice.
It is the two of us as lawyers. And then, of course, we have amazing support staff that assist us. We couldn't do it without them. And what you touched on, what is most important to us is developing those relationships. We're incredibly grateful to our clients. We say it all the time, and we truly mean that we have the best clients. We hug our clients a lot, which is unusual. And then the public education is key to us. And it's our way of giving back to this community that's been so supportive of us in our practice. So it's really the least we can do. So I hope that through the webinar, everyone's able to take a tidbit or two of information and take it back to their own professionals, their own lawyers, and then really explore it if it's relevant to their own situation.
Absolutely. You know, we got so many questions from people who are registered for the webinar today, and we won't be able to get to all of them, but a lot of the questions that came in were questions that I had too. So, Natalie, I mean, let's dive in with, first of all, let's talk about powers of attorney. What are they? Why do we need them? And what happens if you don't have them?
Yes, very Amazing question, and let's absolutely start there. I mean, I could speak for 3 hours on this alone, but hopefully I can at least share the general knowledge that people can then take back and apply to their own situation. Okay, so a power of attorney is a document in which you, the grantor, the person signing the document, is choosing a substitute decision maker for themselves. Now, it was a very poor choice of term, I would suggest, by the Ontario government to call this person an attorney, because as we know, an attorney is a lawyer, in the United States, but in Ontario, attorney means substitute decision maker. So, and what they've established under the law is, generally speaking, every decision a person makes falls under one of two categories. It either has to do with your assets, your property, your finances, or yourself, your personal care. So there's two different kinds of powers of attorney in Ontario: a power of attorney for property and a power of attorney for personal care. Now, you can, and in these documents, you appoint an attorney. Best advice is that you also appoint at least one alternate. So if that attorney can't act for you for whatever reason, you then have an alternate person who could step in. You can appoint more than one attorney to act at the same time. So you can appoint 2 or 3 people to act jointly. They can act in 2 different ways: jointly, meaning they have to make every decision together, or jointly and severally, meaning either or. So one of the named attorneys could be making a decision. That can be risky in some situations, the jointly and severally, because it's possible that one attorney is off making a decision that the other attorneys don't agree with. So before going down that path, you want to make sure that your attorneys will get along very, very well. On the flip side, it can be more practical in the sense that, especially if your attorneys are in different locations, we don't need 2 people going off to the bank to do every transaction, for example. And you can have the same people appointed under your power of attorney for property as you do under your power of attorney for personal care, but you don't have to. It really should be a consideration of who is the best suited to do that role. And it's potentially not the same person, because we all have, our strengths. Under the power of attorney for property, someone who's basically well organized, would be on top of things. But what I think is key is somebody who would be willing to go out and get the information, the professionals that they need to do the job. Very few people are trained, if any, to be a power of attorney for property. So you just want someone who would accept the role and then surround themselves with the professionals that they would need to do that job. Arguably a lawyer, a financial planner, and an accountant. On the personal care side of things, you want someone who, for lack of a better description, would have the stomach to make the decision you would make for yourself, even though it might not be the decision they would make for themselves, because that's really critical, and we kind of don't think of it in that way, but you really are asking the person to step into your shoes and make the decision you would make for yourself. So like I said, you might have 2 children that you appoint in both these roles, or you might appoint one in one role, one in the other role. And then when each acts is very different. Okay, so a power of attorney for property, if it's a continuing power of attorney for property, that means that it can be used as soon as it is signed by the grantor. So the grantor could be perfectly capable of managing their own finances, but they direct their attorney to go off and do XYZ for them. A good example is someone later in life, maybe they're perfectly mentally capable, but maybe not so mobile, or maybe not so computer literate. So online banking has become a challenge. So at that point, they ask their attorney to start doing things for them. And the power of attorney document is proof of that attorney's authority that they can then take to the bank and do certain things. Where it's a continuing power of attorney, what that means is that should the grantor become incapable, the attorney can continue to act for them. It is possible to have a power of attorney document that sets out the conditions under which it can be used. For example, it could set out that it's not to be used unless the grantor is incapable, and it could set out how that incapacity is to be determined. I've only ever drafted one of those powers of attorney, and after doing that, I vowed that I would never do it again, because I do feel that it is a disservice to the client. It would be so difficult to actually put that sort of document into effect, because capacity can fluctuate throughout the day. So short of, full-blown Alzheimer's, for example, where, it's clear that you're not capable, the capacity is not coming back, it would literally be impossible for the attorney to know when they should be acting. So I don't advise clients to have those documents. And the reality is that a lot of powers of attorney for property are used while we're still capable, but like I said, not able to attend to our finances for whatever reason. On the personal care side of things, the law tells us that we're meant to look at each personal care decision on its own, and your attorney should only step in and make those decisions for which it's felt you're incapable. So, for example, someone with dementia might be perfectly capable of deciding what they're going to eat and wear on a given day, and nobody questions those decisions. But maybe they're meeting with their doctor needs consent to a treatment, doesn't feel they're capable of that particular decision, and then so calls on the attorney to make that decision for them.
Can I just ask you, that seems very tricky to me. I'm remembering my mother, and who I had power of attorney, so did my sister, for our mother. And in many ways, my mother had lots of capacity until she died, but she did have a diagnosis of dementia for about the last 10 years of her life. And what she lacked was insight into implications of decision-making, risk factors, etc. So she would have argued that she had capacity to make a decision. And I remember somebody, I think it was a geriatric advisor, saying, there is no law against making bad decisions. And so how do you balance the rights to autonomy and decision-making of someone who has fluctuating capacity or gaps in their capacity? And I guess I'll just leave it at that. How do you go about balancing that?
It's very, very difficult. That is the most difficult thing about powers of attorney, is knowing as a power of attorney for property, when should I be stepping in? And I mean, unfortunately, there's no clear answer. What it comes down to is exactly what you said. It does have to be a balance. The law tells us that the starting point is a presumption of capacity. So every one of us we're presumed to be capable. And so an attorney should step in when there is reasonable evidence to believe that the person has become incapable, which means really seeking out the information you need to make that decision, whether it's from caregivers, doctors, other professionals that individual works with, which I know can be difficult because those people are also governed by the duty of privacy that they owe to the individual. But at the end of the day, our law really much turns on the question of, well, what would a reasonable person do? So I think, an attorney can be somewhat safe in the knowledge that as long as they're doing what, one could argue a reasonable person would do, seeking information, stepping in where it's clear that, or where they really, there is evidence to suggest that the person is incapable. But that individual is absolutely right. There's no law that tells us we can't make bad decisions. And then to always ensure that as the attorney, you are acting in what you believe are the best interests of that individual. So, if you have a concern of them being harmed or that they could be vulnerable to, people who could be taking advantage of them, then yeah, I think you'd be motivated to start acting. And I mean, best case scenario, which I know always doesn't happen, is that you are working in tandem with the individual, which I know can be difficult because none of us want to face the fact that perhaps our capacity is diminishing. We might not even have an awareness of that, which can be difficult to navigate for sure. And in a perfect world, maybe we could have everyone undergo a capacity assessment and then we would know who should be acting and doing what. But the reality is as well that an individual has to consent to a capacity assessment. So, along with that goes the fear that, well, if I consent and I'm found incapable, what does that mean for me? I lose all my rights to make decisions. So it's very difficult to navigate for sure.
Yeah. And this comes back to a question that we had a lot from people attending today is, when should you proactively begin this process of acting on your power of attorney, assuming that you have power of attorney for health and for property? What's too early? What's too late? If there were just some life lessons that you've learned from years of doing this work for both types of powers of attorney, what would you say? How would you answer that question? Is there a right time to begin sort of taking charge of someone else's affairs?
Absolutely. So, I mean, the right time to have these documents done is now, always. Everyone over the age of 18 should have powers of attorney. And we can talk about what happens when you don't have them. I think we should, because that's, in many ways, it's even worse than not having a will, because you're still here and someone, needs to manage for you. On the property side of things, if parents are aging and they're willing to, at least starting the conversation is now, always, just to have those conversations about, mom and dad, are you ready to share, or whoever your loved one is, are you ready to share with me what your assets are? What would I have to manage? Where can I find all the information? At least, assuming they still have capacity, getting them to just assemble things, who are their trusted professionals that I should reach out to? What banks do you deal with? You might be starting with no information. So the more they can put together, the better. And then if they're willing to have you start doing little things, that is always best case scenario, so that you have time where there's no urgency, everyone's happy, things are, going along, and you can just kind of start to familiarize yourself with their affairs. You can establish working together, so that it's not a situation where there's been a crisis, some sort of urgency, and lo and behold, you have to step into a role you're not trained for. You don't even know where to begin. Loved ones are feeling overwhelmed. So anything you can do while things are going well, which I know when things are going well, we don't want to turn our minds to these things, but even the act of preparing, of knowing where everything is, kind of having a sort of game plan should things go wrong, brings such incredible peace of mind. And I know I'll say that over and over again, but it's it's from, years of hearing people say after they've signed their documents, oh, I feel so much better that this is done, that knowing we have this in place. On the personal care side of things, it's really about just having some conversations about what the grantor's wishes would be, because the law tells us, and the law I keep referring to, especially in this area, is called the Substitute Decisions Act. It's a very comprehensive piece of legislation, but I feel it is one of the more readable pieces of legislation, and it guides someone acting under a power of attorney to their duties and responsibilities. And what it tells us is that if you're acting as a power of attorney for personal care and you need to make a decision, you are meant to make that decision based on the wishes that the individual has expressed. So your first job is, well, you may know things, or to try to find those wishes. So conversations can be had ahead of time, just generally getting a sense, okay, well, how would what if this happened? Of course, you can't address every situation, but just, a general sense of, how the loved one would want decisions made can be helpful. Lacking, or if you don't have knowledge of wishes, you're meant to act. The SDA, the Substitute Decisions Act, says that you must act in their best interests. So any conversation can go a long way to, hopefully those decisions never have to be made by you, but you do want to be prepared.
Yeah.
Oh,
there are so many questions that we're getting in. I want to take a few right
sure.
now. So we have someone saying, and we're getting questions both in the chat and the Q&A, and I'm going to just address a few of these
Sure.
right now. First, Aaron writes, I have medical personal care power of attorney for my dad. The issue is he is capable of making decisions, but he cannot talk. So I need to book all his follow-up care and make sure he has everything he needs, but doctors and care home staff will not speak with me. So
that's a common issue. And you, at the end of the day, you are at the mercy of the whoever you're dealing with, the institution or the individual. So perhaps getting something in writing. I would have the power of attorney for personal care, and then perhaps a letter, a statement signed by dad that you do have the authority to make these appointments, discuss things. That should help. Yeah, I would think that's the way I would go. And then presenting both those documents to whoever you're dealing with and seeing if that does the trick.
yeah, yes. Okay, and here's another one in a different caregiving scenario. How do I help my adult child with whom there is no guardianship agreement? And I have lots of questions about guardianship,
Please.
who is severely mentally cognitively impaired, I'm guessing, but she doesn't realize she doesn't have insight into her own cognitive impairment. She is not an immediate harm to herself or others, but her delusions lead to barriers in healthcare. This is a very common scenario in mental health too. And are there any legal tools that can be used to protect people who don't have insight into their own flawed decision-making, particularly in healthcare?
Yeah, that can be difficult for sure. I would say that really the only tool we would have is guardianship. So maybe I'll back up a bit by saying, so guardianship is another form of a substitute decision maker in Ontario. So firstly, we have our powers of attorney, which is generally first or best case scenarios that we have an individual who can sign their own powers of attorney and appoint a substitute decision maker for themselves. Where we have an individual who we believe to be incapable and they haven't signed powers of attorney. So when I say believe to be incapable, we believe them to be incapable of signing their documents, as well as either making personal care decisions or making property decisions. So capacity is situation specific. So we would assess a person's capacity based on a particular situation. So there's a specific test in the law as to the legal capacity that someone has to have to sign a power of attorney. And then there's a separate legal test of the capacity someone has to have to manage their own property. So back to our situation where we have an individual, we believe they're incapable. We believe they're incapable of signing their documents as well as either making these decisions. We then have to look at guardianship in order to get a substitute decision maker appointed. Generally speaking, that would entail a court application. So we apply to the court to be appointed as someone's guardian. And what we have to show the court, two things. We have to provide evidence of incapacity, which best case scenario is a capacity assessment. Now, if individual refuses to undergo an assessment because you have to consent to it, you can get a court order for that person to undergo an assessment. Or which you would get, especially if, if there was a mental illness, there was potential of danger or harm to the person. Or you can use other evidence. So if you did have some assessments from whatever doctor's evidence, whatever you can get to put to the court to prove that they are incapable. And then the second part of the application is to show the court that there are decisions that this person needs to make. And because they're incapable and there's no substitute decision maker, there's no one to make these decisions. Because from the court's perspective, like I said, we're all presumed to be capable. So when the court is appointing a guardian, they view it as removing someone's rights to make their own decisions. So they're not going to do it lightly. Guardianship is meant to be a last resort. So yeah, there is another way to get guardianship for property, but maybe I won't go into it. It's involving the public guardian and trustee, but generally speaking, we're looking at a court application.
Okay, so tell us about capacity testing. Who does it? How is it done? And should people be afraid of it? How hard is it?
Yeah. So capacity can actually be assessed by different people for different purposes. So, for example, when I'm meeting with a client, I do have a professional duty to, it's not a formal assessment, but to assess the individual's capacity to sign documents. In other words, like I shouldn't have a client sign a power of attorney for property that I have reasonable evidence to believe that they don't satisfy the criteria under the Substitute Decisions Act for signing that document. When a doctor also, when they need a consent to treatment decision, they are doing an informal assessment of that person's capacity to make that consent decision. Formally speaking, there are capacity assessors who are trained by the government to make assessments pursuant to the Substitute Decisions Act. So for things such as signing powers of attorney, managing property, most of them will also assess testamentary capacity or the capacity to sign a will. Even though that's not addressed in the SDA, it's kind of, in that world. So for those type of assessments, we generally see those for guardianship applications to provide us with the evidence that we need. Otherwise, or in our practice, we would sometimes advise clients to have that assessment if if we have concerns about their capacity to sign a will or powers of attorney, or sometimes we do it proactively if we're concerned about a potential challenge to the will after the person has passed away. Sometimes even if we believe the person is totally capable of signing a will, we'll go so far as to have the capacity assessment so that we have some evidence to kind of stop that challenge at the end of the day. Should people be afraid of them? Well, potentially, because if you are found to be incapable specifically of managing your property, I mean, that can be used by someone to get a guardianship application, which essentially removes your rights to make your own decisions.
Mm-hmm. So another question that we got in, all of these things are interrelated.
Absolutely.
You can see how in families, unless everyone agrees and there is a plan in place, this can lead to so much grief and pain and suffering, really. But what happens if there's more than one power of attorney, and the powers of attorney, the people do not agree? How do people work out? And I'm thinking, I mean, of course, it's going to be pretty catastrophic if it has to do with property, but it's even more catastrophic if it has to do with health care decision making.
Absolutely.
End of life, pull the plug or
Absolutely.
not,
Yes,
early.
exactly. And I always remind clients for the appointments of executors and powers of attorney to really be mindful of the fact that the children or family members, whoever they're appointing, will not likely be themselves as they are today. Because if they're acting, there might be a crisis, you might be sick, you might have passed away for an executor. So there's also going to be all that emotion. So just because your kids get along today, while you're healthy and fine, does not mean they're going to get along, should there be a crisis. So to really give consideration to that. Like I said, there can be benefits to a joint appointment, but they can go very wrong. And unfortunately, we do see that. So where there are issues, we're not litigators. So when we encounter these issues, we do always try to assist the parties as best we can to resolving these issues. And a lot of the times it's simply encouraging open lines of communication. It's a weird phenomenon, more so with the states, but also with powers of attorney, that at some point all of our old childhood hurts that exist in the family all seem to come up again. So there's so much clouding our judgment, for lack of a better description. So we do try to get families to hone in on the issue at hand as best they can. Suggesting mediation is always a good place to start as well, just with a neutral third party who can at least kind of really boil that. Often that's a good way of really teasing out the relevant issues and getting people to focus and kind of put everything aside for the moment.
So how do you find a mediator? Is that something you would do?
We're not mediators. There are rosters of mediators that the Law Society would have that could be contacted. And often mediators are focused in different areas. And I'm not sure if it happens in power of attorney litigation, but for sure in estates litigation, if really the matter can't be solved. And unfortunately, the parties end up in the court. Often, and two ways that can happen. An attorney under the Substitute Decisions Act always has the right to approach the court and ask for directions, which is maybe a way to solve the issue, is just to put it to a judge to determine how a particular issue should be solved. Or unfortunately, sometimes a party will bring an application to have an attorney removed.
Okay.
If the fight gets really bad. And as part of, sometimes there's mandatory mediation, which is nice. It's the court's way of trying to keep it out of the court system and have the parties work through the issues themselves.
Mm-hmm. And we have a question too about now we are speaking from an Ontario legal perspective, but I mean, I'm guessing that worldwide there are common human, these are common human challenges, and they're going to be dealt with in one way or another locally, so that people should speak to a lawyer regional to themselves. Wouldn't that be the case?
100%. Substitute decision making and estate legislation is province specific. Now, across the country, our laws are fairly similar, but yes, absolutely. Seek advice in whatever jurisdiction you're in to determine what the legislation of that place looks like.
Right. Yeah. Now let's turn our conversation, Natalie, to wills. And in our family, we were really lucky that my mother had made a will a long time ago. She was really proactive because her father was a lawyer, and her father died in 1930 when my mother was 11 years old, and her lawyer father died without a will. And, it caused all kinds of problems in the family. So she had a will, and she had a prepaid funeral, and she had all her wishes were documented, which made it so much easier for me and my sister. I mean, I cannot begin to say what a gift that was from our mother. And so I am wondering if you can talk a little bit about the scenario, which I know is common in families, where people say, I don't want to make a will because that makes me face my mortality. And a person refuses to talk about what their wishes might be in scenarios of dying and so forth. So what would you say are options within families to kind of nudge people along to do some advanced care planning? And what is advanced care planning? And what about medical assistance in dying? So that's a big, huge mouthful right there.
Yep.
But what about wills and all of that?
Yes, I'll start with the wills. So, I mean, we always like to start from a place of positive, and you took the words right out of my mouth. Doing a will is truly a gift to your loved ones. And I always say, remember when this happens, everyone's grieving. So the more you can do to make things easy for them, the better. So just encouraging them, again, that it is a gift. I know it's very difficult for all of us to face our mortality and do the will, and we do try. And what can go a long way is finding a lawyer that your parents or loved one, whomever, are really comfortable with, because we often have clients tell us that, and not to pat ourselves on the back, but that we make the process painless and less stressful, which it should be. So just finding someone you're comfortable with can go a long way to easing some of the concerns. And I mean, if the gentle positive nudging doesn't work, then maybe we do a little rely on the, not the scare tactics, but just the reality of what can go wrong when you don't have a will. One of the biggest difficulties is that there's then no executor. So nobody can do anything until an application is made to the court to have an executor appointed. So everyone's hands are tied for months, which can be devastating for families if they need to rely on that money. It can be very difficult. And I mean, the other issue is that you then don't get to decide how your assets are distributed. So you've worked your lifetime to, amass these assets. And then at the end of the day, you're going to leave it to the Ontario government to dictate how things are distributed. Doesn't make a lot of sense when, we kind of look at it that way. And then there's also, it's a huge missed opportunity, to provide in a special way for a particular beneficiary, whether it's to protect ODSP benefits or to delay the age at which a minor would receive their inheritance. Most parents are horrified at the thought that their 18-year-old could receive their inheritance, which will be the case if they don't have a will with a trust. And then you also miss out tax savings opportunities and all that. So, the hope is that in that conversation, something about that's going to tweak with your loved one to be like, oh, I really should get this done. And then really just encouraging and reminding people you are going to feel so good when it's done. You face it, you do it, and you put it aside. You don't have to think about it. So that, you really do feel better when it's done.
Yeah, absolutely. Can you just mentioned the word trust. So what are trusts? What are different types of trust? Why would someone want one?
Absolutely. I love trusts. I think they're an amazing, especially estate planning tool that we can turn to achieve many of our estate planning goals. I know they're a weird concept. We know what a trust is, but legally speaking, it's actually a relationship that's created by the settlor. In the case of a trust that's in a will, the will maker is the settlor. So they're creating this trust within their will document, and the other parties to the relationship are the beneficiaries. So who's going to receive the benefit of this trust, and the trustees, who's going to manage the trust on behalf of the beneficiaries. It's not considered a legal entity like a corporation, but having said that, a trust can own any asset that an individual can own. So all sorts of assets can be held and managed in this trust. A trust is a separate taxpayer. So one of the duties of the trustee is to file annual income tax returns for any income earned by the trust assets, just like for an individual. Prior to 2015, a trust created in a will called a testamentary trust was taxed at graduated rates like individuals. So we use trusts a lot more extensively because we could, if we had a beneficiary, we could flow their inheritance into a trust of which they were the beneficiary, and they could income split with their trust. So they would take their inheritance without the trust situation. They would get their inheritance, they'd invest it, it would earn income, and they would have to pay the tax on that earned income. We can put it where it went into a trust. The trust could pay the tax on the income earned on the inheritance, potentially at a lower rate. So it was a tax splitting mechanism that we used. 2015, the laws changed, and now trusts nearly across the board, there's a couple of exceptions, are taxed at the highest marginal rate. Having said that, though, they're still very useful in particular situations where we have a beneficiary who receives disability benefits from the government. There's a particular type of trust, a Henson trust, that can be used to protect their government benefits, meaning we can flow their inheritance into a trust and their benefits will not be affected. I mentioned minor children will often include a trust for minor children simply to delay the age at which they would receive their inheritance. And then we also use trusts sometimes in second marriage situations where we want to have the estate available for a surviving spouse for their lifetime, for their care and support. But then on their death, perhaps we want to direct the estate back to children from a prior marriage, for example. So they're less useful than they once were, but still very useful in certain situations.
Okay. Well, thank you, for that information. I know that there are families of adult children with disabilities here in the audience. I recognize some of the names myself. So that's very useful information for us. So I'm just going to skip around to different questions that we're receiving. And we've had a few about if you can't afford a lawyer and you do your own will. I know that you're going to be sharing a list of valuable resources in an email that goes out to all of the registrants, and that email will go out tomorrow along with the recording of our webinar today. But Are do-it-yourself wills as effective as a will that's drawn up by a lawyer? And what considerations should you have if you really should be going to a lawyer because maybe it's too complicated?
Yeah, it is a tricky question, but I certainly appreciate where it's coming from. And unfortunately, yeah, it's not that those will kits are bad wills, are badly drafted by any means. And the issue is that, you know, we're very much advocates of comprehensive estate planning. And the issue is that I mean, I could draft you a beautifully drafted will, but if I haven't looked at your particular situations, explored your unique family situation, and particularly looked at how you hold your assets. And what that means is, are your assets joint with anyone? Have you named beneficiary designations? Those things dictate how your assets are going to flow at the end of the day. So if we don't kind of do that in tandem, we can't, say with any certainty that your estate planning goals will be met. For example, something we see a lot is that if we have a trust and a will, we have to flow the assets into the estate in order to get the money into the trust. So
Right.
sometimes we do that planning, we have the trust, and then off go our clients. They meet with another very well-meaning professional who perhaps advises them to name a beneficiary. Well, of life insurance that offers probate fee savings, it offers creditor protection. That is true, but the goal we had prioritized, for example, for an adult child with a disability receiving ODSP, our main goal is protecting their ODSP. So now that life insurance isn't going to the estate and isn't going to go into the trust. So we've undone our estate planning. So, I can't say with certainty if person lives to a ripe old age of 95, they have one bank account, one investment account, maybe that home kit will do the trick. I can't say. So, I wouldn't want anybody to settle for a cookie cutter approach. Everybody knows their own situation. We do meet with a lot of people who tell us, oh, it's really simple. And then when we start to delve in, it's not so simple. So best advice, I mean, of course, like with all things, you can find fees for drafting a will from a few $100s to a few $1,000s. So what I would suggest is finding a lawyer that you're comfortable with and check out their experience. Wills used to be something that every lawyer would kind of do on the side, but as a profession, we in the law society, everyone's decided that that's no longer appropriate. So find one, of course, that fits within your budget with the most will experience that you can get. And then hopefully at the end of that process or particular experience, if you do say, for example, have a child with a disability, seek out someone who has that particular experience of working with those clients so that at the end of the day, you do have a good will.
Yeah. And I know in some places there are legal charities or legal aid available for pro bono services for people with disabilities and their families. So I guess that would be worth checking out as well.
Absolutely. I should, and I could add that actually to the resources. In Reach is
Reach.
Reach.
We used
Now
Reach
being
our son is
managed by oh dear, it just ran out of my head. Able to.
Yeah.
So yes, you can get up to 3 lawyers, or I'm a Reach lawyer. You would get, matched with a lawyer and can receive up to 3 hours of pro bono. So that's a great opportunity for sure.
Yeah, absolutely. Now, I want to ask you as well, because there are a few people asking in the chat about this as well. I mentioned medical assistance in dying.
Yeah.
In Canada, people have a right to request medical assistance in dying. And I'm not sure where it stands now in terms of putting it in your will. Is it possible, for example, and the scenario in my mind would be your parent has this in the will and you don't maybe even know, is it possible to put in your will, if I get Alzheimer's and I'm in stage 7 or whatever it may be, under the following conditions, I predict or I order in my will that medical assistance in dying be performed on me. And you're saying that in a future hypothetical set of circumstances. Is there a legal precedent for that in Canada right now?
So I'll start by just looking at the broader, it would kind of be a part of the living will or the advanced care directive that we like to include right in the power of attorney for personal care, because it would be that individual who's potentially making decisions for you. So I kind of view the living will as a more general expression of your wishes. Like I mentioned, the attorney's meant to, or is required by law to act in accordance with wishes you have expressed. So your living will is essentially your opportunity to express those wishes, and it can say whatever you want. Generally, it's a no heroic measures clause. That's what's most standard, just to say, attorney, if you're ever advised by my doctor that there's no hope of my recovery, this is what I would want to happen. Maybe pain medication, water, but it can go into whatever specifics you want. I see an advanced care directive more specific, kind of considering certain situations and giving more specificity to your wishes. I just had this discussion with a client yesterday, actually, having been through this personally with my dad who passed from cancer. I think I'm more on the side of a general living will, because after being through, which maybe, there's some things you can't know until you've had the experience. Yes, you can sit and say, oh, if I had cancer or Alzheimer's, I'd want X, Y, and Z to happen. But what we forget is, how do we know the surrounding factors? What other medical conditions do we have? How long have we been fighting this disease? There's so much more that would go into it. I think our attorneys are better served by, ongoing conversations, if possible, as you're progressing through your illness, but just more general idea of this is what I would want. And then how MAID factors into that. So what the law says right now is that you have to be capable of requesting medical assistance in dying. And then you also have to be capable when the procedure takes place. So your power of attorney would never be involved under the law now, because they only step in if you're incapable. Having said that, we don't know where the law is going. They are looking at advanced consent. I have no idea what that might look like. So we have started to include some clauses just kind of to indicate whether the grantor is supportive of it and would want it to be explored, should it be allowed, and should the situation exist, or whether they're very much against it and wouldn't want it explored at all. So all that to say is, yes, you could include such a clause, but under the law now, it wouldn't be effective. But we're including them, thinking that if the law changes, at least we have those wishes expressed.
Right.
Yeah.
Okay. There's so many more questions. We could go on, and but I think the takeaway that I hope that people leave with today is that doing your wills, having these conversations in your families is a huge stress reliever, actually. And it's an act of love and an act of caring. So certainly I can testify that my mother's will was an act of love for me and my sister. She removed everything from our shoulders and gave us the inheritance that she had. And her powers of attorney enabled us to, help her at the end of her life. and knowing that we didn't have to second guess. We pretty much knew everything that she wanted because it was down on paper, in her will and in her powers of attorney. So I hope people are able to take that away today. Natalie, thank you so much for joining us. It's just been such a rich conversation. And I learned so much. And I hope that people will have increased knowledge to be able to bring to their own legal counsel, and be that much more educated with the questions that you're able to ask, and thereby save some money too. So thank you very, very much for joining us today. And I know we have a slide with your contact details on it that we can show. Over to you, Christine.
There's mine. Thank you very much. Yeah, that was very informative. Lots of questions. Jen and I have been furiously typing into the chat. Just a reminder, yes, everyone, this is being recorded. You'll get an email tomorrow, and in that email, you'll not only have a link to the recording, the YouTube recording, but we'll also put in the resources that Natalie has shared with us, and there will be two forms, two attachments in that email that is for you. And before we leave, I do want to share that we do have our next talk coming up in November the 21st. We have Dr. Anthony Levinson. So for those of you who are viewers of the Optimal Aging Portal webinar series, we're cross-promoting. Anthony is going to be joining Donna for a discussion on aging and dementia information now, McMaster's treasure trove of resources. Oh, thank you, Jenna, for putting that up. So if you have a smartphone, you can take that out, and the QR code there, you can that will lead you to registration link, or I think Jen will put a link into the chat, and I will also include a registration for that talk into the email. So a full hour, lots of information. Thank you everyone for all of your questions. Hopefully most of the questions were answered, but I think we could talk on this topic, Natalie, for 5 hours and we'd still just be covering the surface. So thank you both for joining us. Thank you everyone who has tuned in from all around the world. We hope you enjoyed the talk today, and we look forward to seeing you again in the future. Thank you everyone. Take care.